Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Good morning. Good morning, everybody. I hope this finds you well. I am having a day. It's a good day. Oh my God, did I just say it? Did I say it?
Had a good day. It was a good day.
Sorry about that, guys.
We had a good day. It was a good day.
So it has been a good morning. A little frantic around here, but that's okay. I had some modifications we have to do, but we have the Sarah Boone, oh my gosh, motion or bond hearing. And we're going to go into that in just a second. But I need to announce something fabulous. Y'all, you need to get your hands together and give a congratulations to some special people. Let me get it up there. Our lovely partners at As the Gavel Drops have launched a YouTube page. Congratulations to As the Gavel Drops. This is a place where you can, I'll read the thing. This is a Discord server YouTube channel where we will share more about how the server works and how you can find the latest information, documents, almost anything trial going related. They have their first short, Join Discover, and this is the P. Diddy. So let's click on it.
Have you ever wondered where would you be able to read documents on the most high-profile cases like Karen Reed at a click of a button? Are you interested in the little-known cases are not widely talked about? If so, please join As the Gavel Drops Discord server, the largest service of its kind. The link is in the description. Have you ever wondered?
Isn't that awesome? You guys have earned it. You have worked hard, and I am so excited for y'all. What a wonderful way to wake up. Oh my gosh, y'all. That is so awesome, and I'm excited for them. And I would like for y'all to go. I've already subscribed. I'm like, we're there. We're there. Went there and subscribed. Y'all go and be a member. Did you post the link, Toxic? Yes, you did. Of course you did. Of course. Oh, of course. I'm reading on the Discord. I'm on their Discord right now, y'all. I am on Discord right now. So we've got Kohlberger coming up. We've got two different things coming up that we're going to go to. Yay! Oh, sunny day. Hello, Toxic. Bama Green Eyes. Bama. I'm just giving you a hard time. Yana. See, Yana. Yana. Bama, BAMA. It gets a little mushed together. Everybody, good morning. Let me bring up the feed. I am trying to find, y'all can help me out here. I'd appreciate it. I am trying to find the court feed for the Larry Ingram trial. I need that court feed. And yesterday they had opening statements, but I can't find a court feed. So if someone can help me find it, because I spent all morning looking for it, please let me know. And let's see, they say we are working on a video to show you how to use and navigate as the gavel drops in Discord server who don't understand the Discord. That is fabulous. Fabulous idea. Okay, let's get into it, y'all. Let me get me. I have to do this. I hate it, but I have to. All right, let's get going. By the way, during break, we have a situation that I have got to tell you about in San Antonio that happened last night. Thought about going on live, but I decided against going on live at midnight at night. But I'll explain everything in a minute. Let me make sure the volume's all the way up. It is. So here we go. Sorry, I need a little something. We have no sound. Of course, we would have no sound. Are you kidding me? Do we have sound at all?
My husband.
Sir, you can stay.
Okay, we do. There we go. Had to fix all that. They may be discussing other things, so we'll try and zoom it.
Yeah, I'm not going to use that one. I found it. You're right. Yeah, I'm not going to use that one. I found it. You're right.
Okay.
Sir, you can stay at council table wherever you're comfortable.
Meaning I don't want you coming up here.
Judge, it's our position that based on the fairly debatable legal issues we intend to raise on appeal and an application of the Youngins factors, that a bond pending appeal is appropriate in this case. And we're going to present the testimony of 4 witnesses to help establish the Youngins factors. I would note that this was a close case where the jury found Ms. Benifield guilty of a lesser included offense. At some point during their deliberations, they were hung and came back to the court and advised the court of that. And I think they had at least one or more questions for the court. So again, it's our position this is a close case, and that under the circumstances, based mostly on Ms. Benefield's history and characteristics as a person, as well as her strong support from family and community, that she should be granted a bond.
No.
Thank you, sir. State, did you want to make an opening?
No, other than I think the court knows the state's position that we would oppose bond.
Okay. All right, Mr. Fennell.
The next call is Janelle Kiesmeyer.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning.
Good morning.
Could you state your full name
Sure. Janelle Kuzmeyer.
and how are you employed?
I am a supervised release officer with Manatee County Probation.
How long have you been doing that?
Coming up on 10 years.
Do you know the defendant in this case?
I do.
How do you know her?
I was her supervised release officer for 4 years.
How long was Miss Benifield out on bond?
She was out on bond for 4 years with me.
And did you monitor her that entire period?
I did
Was Ms. Benefield on GPS monitoring when she was released?
the whole time, yes.
Did she ever violate any terms of her monitoring?
She did not.
Did she ever violate any other terms of her release?
She did not.
Did she abide by the terms of her curfew?
Yes, she did.
And did you have any issues with Ms. Benefield otherwise?
I did not.
Did she keep in contact with you?
She did, yes.
Was she honest with you?
I'm sorry.
Was she honest with you?
As far as I know, yes.
Did Ms. Benefield maintain employment while she was out on bond?
She worked for several different employers, but I don't know if it was consistently through the 4 years, but she did have several different jobs.
Were there times during your monitoring period that the court granted Ms. Benefield permission to travel outside of the jurisdiction?
Yes, one time out of state and at least, I believe, 2 times to Orlando.
Did she keep you advised of the details of that travel, including dates, times of when she was leaving and returning and where she would be staying?
Yes, she was very good about communicating those things.
Do you have any reason to believe that Ms. Benefield would be a flight risk if released on bond pending appeal?
Based on my 4 years with her, I don't have anything that jumps to me thinking that she would flee.
Thank you. No further questions.
Cross?
Yeah, but she wasn't convicted of murder.
Excused?
Yes.
A red room.
State?
Yes.
All right, ma'am, you're excused. Thank you very much. All right, your next witness?
The defense calls Dr. Barbara Russell.
Can anybody help me find the trial link for the Larry Ingram, Denique, Deniq Ingram murder trial, please, Bond? Court is super low. It's 100% gained on my end.
In the meantime, we'll call Laura Zito.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
There's her mother back there.
Morning, ma'am. And that does adjust if you need to move it up, down, left, or right.
Okay, thank you.
Good morning.
My name
Please state your name.
Laura Zito
Where do you live?
in Manatee County
How long have you been living in Manatee County?
for 8 years.
What do you do for a living?
I'm a stay-at-home mom,
And how long have you been a stay-at-home mom?
7 years,
How many children do you have?
5.
Oh, wow, 5. Do you know the defendant in this case, Ashley Benifield?
I do.
How long have you known her?
For just over 9 years.
Did you and Ashley spend time together with anyone else? Any other friends in your group?
My husband,
How about other young mothers?
throughout all the years, it was pretty much us two.
Okay.
Yeah, there are a couple times where we had other people around at gatherings and stuff, but we would hang out together.
Okay. Could you describe for the court who Ashley is as a person?
That's
She
a loaded
is
question.
a very genuine, honest, loving, giving, very gentle person.
And have you had the opportunity to observe Ashley as a mother to her daughter?
Yes,
Could you describe how she is with her daughter?
she's very loving, very patient and kind. She's attentive. She's helpful in every way, just always ready to do anything for her.
And have you continued to support Ms. Benefield since the incident in this case?
Yes.
And if she's released on an appellate bond, would you continue to support her?
Yes.
Do you have
Wow.
any reason to believe that Ms. Benefield would be a flight risk?
No.
Thank you. No further questions.
Cross?
Interesting.
Hold on, ma'am.
Sorry.
It's all right.
You're not used to testifying, are you, honey boo?
Now you're all set.
Thank you. The defense calls Jana Martin.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Good morning, Judge White.
Good morning, ma'am. As you sit down and make yourself comfortable,
Yes.
that microphone adjusts up, down, left, right, however you need it.
Thank you.
That's her mother.
Good morning.
Good morning,
Could you state your name for the record?
Ooh, look how she's sitting.
Jana Taylor Martin.
Where do you live?
I live
She
at
had gone.
2510 Loma Linda Street, Sarasota, Florida.
And how long have you lived
Bible
in the
teacher.
Sarasota area?
That's a Bible teacher and
Almost 40
chaplain.
years.
Did you see the
What do you do for a
swagger?
living?
Okay, did you see the swagger on her? And look the way she's talking. She reminds me of a friend I have who was the first female trail boss for the cattle drive between Texas and Oklahoma that followed the same path as they did way back in the 1800s. God, she must be, she must be a bless.
Well, right now I am a missionary and a Bible teacher and a chaplain. But I
Oh,
started out
look-
as an elementary school teacher and I sold.
Oh, look at that. Oh, aren't you so proud of yourself? You got someone up there who's a chaplain. Oh, look at that smile. I think we're going to screenshot that one. That's
Real
just too
estate,
good
40
to not
years.
do.
And do you
Oh,
know
I'm
Ashley
so
Benifield?
special.
Yes, I do.
How did you meet her?
I met Ashley in 2016 when I was called to do a prayer initiative for President Trump, and she was the
Let me let
coordinator
the cat
between
out.
President Trump and the women that prayed and interceded for him.
And is it your understanding that Ms. Benefield lived in the Bradenton or Sarasota area since 2016?
Yes, she did. She lived first with Barbara Russell, and then after approval, she moved into our guest house, 15 steps from my back door.
And in the time that you've known Ms. Benefield, did she have family and friends in the Manatee County area?
She did.
And did you and Ms. Benefield participate in any church groups?
She was in my
Oh,
Bible study.
Well, of
Even her
course,
little
honey.
Emerson that's 7 now, and her mother,
Aw.
Mimi. So yes, she did. And I have been walking with Ashley for 9 years almost.
Oh,
How
aren't
often do
you
your Bible
just
study meet?
A
special?
weekly.
How many people participated?
It's all women, and it would vary anywhere from 8 to 14, except one time. A man
Bless
came.
your heart.
One time
You're
a man
just
came,
so
one man. That
sweet.
was all. That was all. And it was just pretty much.
Okay, for those of you who don't understand, I don't know why. I'm having to go and fix the closed captioning. Okay, so the size is on their end, not my end. Sorry, guys.
Here's almost.
So when I say bless her heart, you poor thing, you've just been so kind to Miss Ashley. That's sarcasm as hell. Just saying.
How often did your Bible study meet?
A weekly.
How many people participated?
It's all women, and it would vary anywhere from 8 to 14, except one time a man came. One time a man came, one man. That was all. That was all. And it was just pretty much focused on the Bible and the
I
way to
bet
walk
it
with
was.
the Lord.
And were there, you mentioned that it was mostly women. Were they women of all ages, from young women to senior citizens?
Yes, they were all ages, and they were from different churches and different walks of life.
And to your knowledge, is Ms. Benefield close friends with any of these people that she met at the Bible study?
Some of them are sitting right there in the courtroom. So the answer is yes.
And do the members of the Bible study, do they continue to support Ms. Benefield?
Yes, not only with love, but they've helped financially also. They've stood with her 100%.
Oh,
You mentioned
good.
that Ms. Benefield lived with you at some point in your guest house?
Yes, she did.
When did that start and how many years?
After this happened, after the incident, she was with Barbara Russell. She wasn't allowed to come be with her daughter in Emerson until it was approved by the
CPS.
powers that be. And then they came to our guest house and we prepared it properly. And we met all the regulations for it. And my husband, which I just lost, it was never any cost. We're blessed to be a blessing. We loved having them there. It was a great gift for us to have them. Yeah.
Oh, you poor thing.
Yeah, me too. He was great.
And you kind of mentioned it. Did you charge Ms. Benefield rent?
Never, not one dime. I didn't want it. We wanted her to be there and be safe. And we believe she was.
And at the time that she was living in your guest house, was she working?
She was. Different jobs at different times and always obedient. I remember I have to be here at this time. It was always, she was very obedient about being on time and right. And yes, she did have different jobs.
And could you describe for the court who Ashley is as a person?
She's precious. I've never heard the child say a curse word. She's mature beyond her age. And she had a position with Mr. Trump, whether you liked him or not, that she did a great job. She was obedient. She had a good position. She led the prayer team. And we prayed for months for Donald Trump before he won. She is a lovely, smart, outstanding, godly girl. Is that enough?
Yes, that is. And did you have the opportunity to observe Ashley as a mother?
Impeccable mother. As a child, I would go to the guest house and she'd be holding Emerson. They'd be talking about dinosaurs. They'd have books. They'd be watching shows. She was an impeccable mother. She put her first. She had her in a ballet. She had her in swimming. She had her in tap. She did everything she could to support Emerson. And
I'm
still
sorry, that
is.
does not make you an impeccable mother.
I wish she could be with Emerson and supporting her now.
How old is Emerson?
7.
And to your knowledge, did Emerson participate in any programs or activities in the local area?
Absolutely. The Nutcracker with the Sarasota Ballet.
Anything else? Any like?
If I may, at my husband's funeral last week, they asked for people to speak. Emerson came up the aisle in her cowboy boots and she took the microphone and she turned around and she said, "I love my Papa Jim. And I understand because my cat died." It's a precious child. She's missing her mother desperately. But I had a smart son. She's bright. She's very, very bright.
Thank you, Ms.
It's
Martin.
just, I know I may be saying too
No,
much.
that's
I'm
okay. I didn't mean
sorry.
to interrupt. If Ms. Benefield is granted an appellate bond, where would she live?
With me.
She would live 10 steps from my back door.
Is that in the guest house or somewhere else?
Actually, it's in another house we own next door that's bigger and more room, where I think they could be a little more comfortable. The guest house isn't that big.
And would she be living there with anyone else?
Yes,
Would it be
her mother and Emerson. And it would be no charge.
And how are they already living there? Her mother and Emerson.
They are.
Do you know how long they've been there?
Yes. Whenever Mr. Neil, I mean, it was around Thanksgiving. Don't hold me to that,
So a
but
couple months.
yeah.
And if the court were to impose conditions of release such as an ankle monitor or curfew, would you help her in complying with those conditions?
Absolutely, 100%.
Whoa.
Do you have any
Yes,
reason to believe
ma'am.
Ms. Benifield poses a flight risk?
Never. Absolutely never. Absolutely never. I believe with all my heart, she would be obedient. She was obedient the last time. I think she would be obedient again.
Just one moment. And would you be willing to be sort of like a custodian for Ms. Benifield? If you notice any violations, would you report them?
Yes, and I'd be a good custodian because I tell the truth and I would be obedient as a custodian. And it would be my honor if the judge's heart would see it. It would be an honor for me to be a custodian at this time. That's going to be hard for me to be alone with. I'd love to be a custodian.
And since Ms. Benifield's arrest, have you been providing her with emotional support?
Yeah,
Will you continue to do so?
absolutely. With prayer, with guidance, and we're going to walk this out. And the Lord rules.
Thank you. No further questions.
Whoo.
Thank you.
I got to tell you,
Hold on 1 second.
I want a friend like that.
Now you're all set.
Hi, Benny. Y'all,
Thank you, Ms. Martin.
as hard as this is for this woman,
If it
she truly believes in Ashley Benifield. I would want someone like that on my side. That's for sure. Oh my gosh.
would be possible if we could try to see if Dr. Barbara Russell is out there now.
Gotta find a place to put this. It gets hot in here, y'all.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Whew. I hope you can't hear it.
Good morning, ma'am.
Good morning, Your Honor. You know what?
Good morning.
Good morning.
Never mind.
Please state your name for the record.
Barbara J. Russell.
And what do you do for a living?
I have a mental health practice. I do clinical and forensic evaluations and counseling.
How long have you been doing that?
I'm here in Florida for about 15 years.
Do you know Ashley Benifield?
I do.
When did you meet her?
I met her in the spring of 2020.
What were the circumstances of that?
She came to my office seeking an evaluation.
And how long have you had a professional relationship with Ms. Benifield?
Pretty much ever since then.
And did you continue to communicate with her after the shooting incident in this case?
Yes.
Did Ms. Benifield live with you at some point?
Yes.
Do you recall when about that was?
Late October of 2020.
And how long did she live with you?
Approximately 8 months until her DCF case was resolved.
And why did you allow her to live with you?
Because I don't think I ever could have held my head up high or looked my kids in the face if I didn't. She was severely traumatized after the shooting incident and everything that had happened prior to that. And because of the DCF involvement, she was not allowed to live with her mother and daughter, and she was effectively homeless. The financial abuse in her marriage had robbed her of all financial resources. And I could not abandon a client and say to her, well, good luck sleeping in your car. I hope you get your kid back. It was out of the question.
Well, that's against code of ethics, no matter what. You can't do that.
Trying to help her through a difficult situation to the best of
You still can't do that.
Yeah, I
That's
made an
against the law.
obligation not to abandon her and to make sure that she was safe and that her daughter's mother continued to be safe.
To your knowledge, how long has Ms. Benifield lived in the Bradenton, Sarasota area?
I believe she moved here, it was like 2012, 2013. She danced for the Sarasota Ballet. She continued to live here after her retirement from the ballet. She did live in South Carolina for a couple of years in the early part of her marriage to Douglas Benifield, and then returned to the Sarasota Bradenton area afterwards.
To your knowledge, does she have any ties to the local community?
Oh, yeah, she has many ties in the local community.
How about a church community?
She has a church community. She participates in various Bible studies and she attends a Torah club as well.
What is a Torah club?
It's like another Bible study. It's a weekly gathering and studying of Torah, and she has friends and fellowship in that group as well.
Are you aware of Ms. Benifield participating in any pro bono work?
Yes, she was working for Elite Teams Ministries, doing a variety of things, some youth mentoring as well as social media marketing.
And could you describe for the court who Ashley is as a person?
Ashley is a very loving mother. Ashley is kind. Ashley is compassionate. She's a good moral compass. She's just an all-around great girl.
You mentioned
Okay.
that she's a wonderful mother. To your knowledge, is her daughter involved in any extracurricular activities in the Manatee County area?
Oh yeah, she's been in the ballet for several years. She's participated in swimming lessons and is involved in different social activities. She has a lot of little friends.
And have you had the chance to observe the impact of Ms. Benifield's absence on Emerson?
Yes, I've seen Emerson a couple of times since her mother's incarceration. She misses her mom. She just wants her mommy to be with her.
And have you assisted Ms. Benifield?
Then her mom shouldn't have committed red room.
Yes, she has a job waiting for her.
And what is that?
She would be working at Bishop's Aluminum. It's a corporation in Sarasota. They make the aluminum parts for pool cages.
Do you know what her role would be in that?
It would be physical labor. She would be starting out like in the factory, doing prefabrication work, and she can move up to assembly.
Wow.
And
Hello,
so
Journey
in
to
this
Justice.
case, have you
Hi, Yana.
provided
Thank you.
emotional support to Ms. Benifield?
Yes,
Will you continue to do so if she's released on bond?
of course.
Do you have any reason to believe that she would flee if released on bond?
No, that's the last thing she would do. She would never abandon her daughter, and Ashley would follow the rules. She would do everything the court told her to do. She is a rule follower. She's always been very structured, methodical. She follows rules. She does things the way they're supposed to be done.
Until you're up for a life in prison, then you can change. The volume in court, I can't change any more than I have.
Judge, we don't have any other witnesses. We have, with the court's permission, there's several people in the audience here in support of Ms. Benefield who are also willing to act as custodians if the court were to grant a bond and to report any violations they became aware of. We've explained to them that if they were assigned that role and failed to do so, they could be held in contempt.
Yeah, I'm all the way up.
I'd simply like them to stand up and state their name for the record.
Okay.
Anyone who's here that is willing to act as a custodian for Ms. Benefield, as we explained, please state your name for the record, starting with you. Pamela Hagan.
Yeah, I'm 100% gained. There's nothing I can do.
Thank you.
So they're just giving their names of who would be back up.
Any other evidence or testimony, just legal argument?
All right. State, any evidence, witness, or testimony?
Judge, I don't have any evidence. I do have a member of the family that would like to speak.
Okay.
God help us all.
Benefield. Yes, yes.
All right. Go ahead.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
It is, yes.
And this is a statement pursuant to Marcy's law?
Yes.
Okay.
it is.
Thank you, Your Honor, for hearing from the family today. As has been spoken in court today, it has been over 4 years since the defendant or the convict killed Doug Benefield in a single shot killing that has been a conviction of manslaughter with a firearm. There are two sides to Ashley Benifield that have been portrayed throughout my longtime association through Doug to Ashley, through all of his business friends and partners who got to see Ashley from the very beginning of the relationship. There are believers, they're in this room and they're elsewhere. And there are people who saw through the actress that we have seen over time. Of that 1,597 days since the killing, she's been out of jail. She was fortunate enough to be allowed out during the COVID time, which allowed her to be on an ankle bracelet and with their daughter from basically 3.5 years old to she'll turn 7 in March. Most of that time, it's almost 90% of the time since the killing, she's been out of jail. She was fortunate enough to get that time. It's clear that the believers, from our point of view, have supported her with money this whole time. But the part of the story that's not told, and I have access to every bank record, our family does, even the week before the killing, Doug had to borrow $25,000 to support the move of Ashley, Alicia, and Emerson to Maryland. And it was just a few days before that he needed the money to even move the family, I'll call it, up to Maryland. So for him to be portrayed as not supporting her is just a lie. We have the bank records, we have the money transfers. So many things in this portrayal today is one side of what she can present. But the reality of Doug paying for her counseling, their marital counseling, providing money, paying for clothes purchases, predominantly paying for almost everything that Emerson required up until the time he was killed. The other part of the portrayal today that Doug did not support her and left her destitute, or not that word, but close enough, is that the supporters have made that happen for her. However, the financial support and the jobs that are talked about, I'd love to know, and the family would love to know, the very few times that she worked during that period. And if we remember back to the first case, especially in court testimony, she was allowed to get out with a job, supposedly with her attorney previous to this case and the child custody and divorce case. That job didn't last. There are witnesses from her work period while she was out on bond previously that have a very different story to tell of who Ashley Benifield is. Since the sentencing and her not getting out, they have come forward. So there's a very different picture of
Oh, he doesn't, it's hearsay, what somebody else had told him. He doesn't think it's right for him to be able to talk about hearsay.
This is not evidentiary. This is not evidentiary. Overruled.
Thank you, sir.
Thank you, Your Honor.
From the first night that I spent the night in Ashley's mother's home, I believe in the room where Doug was killed. The next morning, I told Doug at coffee I would not stay in the house anymore due to the evil in the house that was not presented, but how I felt about being there. And I went to a hotel that night and stayed. So I've been around Ashley for many years personally. There are other people who, matter of fact, Trip Cormany, who married them. I know for a fact that she can present two ways, and she has throughout this case. And if you believe her, then this is a case of that. She's had the financial support to get through all of these trials and all this time, all of these attorneys, without her paying for them. So I do believe,
Good point.
the family believes that she has the ability, especially now that she's been sentenced to the 20 years and 10 years, and she's had financial support all along, that would be very simple for her to avoid this prison time by having supporters provide money for whatever they say it's going to, and it's very simple to get out of the United States and disappear. We believe as a family, as the supporters of Doug, that she's not the same person now, nor would she necessarily behave the same way as she did in her first bond period for
That's a good
1,300
point.
days.
Got a lot more to lose.
We do not believe
Kidnap her
any-
daughter and skip the country.
last part of what the family, and I'll call it family, is that there is family of hers that would not come forward to speak with us and tell us the truth about how threatened they felt. Direct family of Ashley's, who has now become friends and family of ours, who would not come forward until the sentencing was done for fear of how she would do retribution on them. So her own real family, outside of the people of Emerson and Alicia, but other members of her direct family, don't believe she will stay, and she will stay during the bond for the appeal to be answered. They can't be here today. They still feel that it would be dangerous for them to speak in person. But as a family, we don't believe that she will stay through any bond that she has. She's been out 90% of the time since the killing, and we believe that she's had the benefit of all that time with their daughter from 3.5 to almost 7. It won't hurt to keep her in jail. She should be kept in jail during this period. Thank you, Your Honor.
Thank you, sir. Any other statements?
Judge, I believe that's it.
All right, and no evidence?
No evidence. I just have argument.
All right. I'll consider the evidentiary portion of the case closed, or the hearing closed, and I'm prepared to hear argument. Thank you.
Judge, I'll start by saying I certainly feel horrible for Mr. Benifield's loss, but I'd ask the court not to consider the speculation and the hearsay testimony about family members that are not coming forward and individuals that are making statements that can't be substantiated. As it's our position under Rule 3.691 and the Youngins case that Ms. Benifield is entitled to a bond pending appeal. As the court is aware, under the rule and the case law, the defendant is normally, and this is from the Baker case that I provided to the court, it says a convicted defendant should normally be admitted to a bail pending appeal if the appeal is taken in good faith on grounds not frivolous but fairly debatable. So it's normally, this isn't an exception, this isn't a rare occurrence, it's the normal course of business unless there's factors that suggest it's not appropriate. And the good faith requirement for purposes of appeal is simply to raise claims that are non-frivolous on appeal that are fairly debatable. I think ad nauseum, the issues that are going to be raised on appeal have been addressed to the court. I think the court would be hard pressed to find that we don't have any fairly debatable issues. I'm not going to go through all of them. I will just point out that I believe there's a fairly debatable argument that the state's closing argument misrepresented evidence. There's a fairly debatable argument that Juror 15 committed juror misconduct that justified a new trial. There was a significant number of rulings by the court prohibiting introduction of evidence that would have supported Ms. Benifield's defense. We think we have a legitimate argument that the state did not meet their burden of proving beyond a reasonable doubt that Ms. Benifield was not acting in self-defense. So there's a variety of issues that I think meet the very low threshold of fairly debatable. And I'd be surprised if the state disagreed that we meet that standard. Once we meet that standard, we move to the Youngins factors. And there's 4 of those. And the first is the habits of the defendant as to respect for the law. As the court knows from the sentencing hearing, from the PSI, this is Ms. Benifield's first criminal incident. So she has a long life of not being involved in any criminal activity. And we also know from her pretrial services officer that she was a 100% obedient person on pretrial detainee with no issues following the requirements of electronic monitoring, following the requirements of a curfew, following all the requirements established by the court. So it's our position that under the case law, the habits of the defendant as we respect for the law weigh heavily in favor of Ms. Benifield being granted a bond. I don't think there's any evidence to contradict that in any way. The second issue is her local attachments to the community by way of family ties, business, or investments. We've heard testimony from today, and the PSI notes that both Ms. Benifield's mother and daughter live in Sarasota, and that Ms. Benifield has lived in the Sarasota-Bradenton area since at least 2016. She has a home that is being given to her to live in by one of her friends, a longtime friend who testified here today. We also have the testimony of Barbara Russell, who was willing to give Miss Benifield a place to live when she was in a time of need. It's hard for me to imagine a stronger showing of support than providing an individual that doesn't have a place to live at no cost. We have a letter from Reverend Brown indicating that she's strongly involved in the community, in prayer groups, in the Torah Club. We have other testimony about her involvement. It's clear that she is tied to this community by family, friends, and work. We have a letter indicating that she has a job waiting for her, and she's ready and willing to start that job to support herself and her daughter when she's released. The third factor is the severity of the punishment imposed, and I would certainly be disingenuous if I argued with the court that a 20-year sentence is not a lengthy period of time. But the Cooley case from the second DCA, 1998, gives a pretty good discussion of how to weigh the sentencing, the sentence. And in that case, the trial judge denied bond because Cooley was facing a minimum mandatory sentence. And what the second DCA said is they have the authority, the legislator has the authority to exclude certain crimes or certain conditions from when people could be granted a bond. So if they wanted to, they could say anyone that was sentenced to more than 10 years or anyone that was sentenced to a crime with a firearm is precluded from being granted a bond. As the court is aware in its earlier order on the bond issue, there is actually a statute that lists crimes that you cannot get a bond for. Manslaughter with a firearm is not one of those crimes. So although the 20-year sentence, I would say, does not mitigate in favor of Ms. Benifield, I think the case law, including the Cooley case, indicates that factor alone is not sufficient to justify a bond. Same issue is addressed by the 4th DCA in the Baptiste case.
Baptiste?
Yes, Baptiste, 4th DCA, 2012. They cite back to Cooley and again say the length of the defendant's sentence is not by itself evidence of flight, and that's the purpose of bond, is to prevent flight. The fourth factor is any evidence that Ms. Benifield would be tempted to remove herself from the jurisdiction of the court, and I suggest there's no evidence of that. In fact, we have the contrary. We have 4 years of strict compliance with the rules. We have years and years of compliance with the laws of the United States and Florida. We have numerous individuals in this courtroom willing to act as custodians and to report any violations. All we have is speculation that potentially someone with a 20-year sentence would be tempted to flee. But again, the case law makes it clear that that fact alone, just the sentence, it has to be tied to a specific fact or something else. You need something else besides the sentence to support the denial of a bond. And with the strong support exhibited here today, it's my position that Ms. Benifield, there's no evidence she's likely to flee, and everything she's done up to this point is consistent with her attempting to exonerate herself based on self-defense. And she continues to want to do that through the appellate process and through whatever means she can. There's simply no evidence that she would leave the jurisdiction in this case. Finally, I point the court to the Dooley case from Hillsborough County. It's a similar circumstances as this. Mr. Dooley, and I met Mr. Dooley, so I have personal knowledge of the case. Mr. Dooley was convicted of manslaughter with a firearm based on an incident which he claimed self-defense. And he was sentenced to 8 years in prison at the age of 72. And two different judges, then Judge Ashley Moody and then Judge Barber, granted bonds pending appeal based on the fairly debatable issues and his history of complying with the conditions of his release. It's our position that the circumstances of this case are similar to those in Mr. Dooley's case. And the Dooley case is an example of why an appeal bond exists. The purpose of the appeal bond is twofold. One, if a person has a good faith appeal and they win it, they really don't deserve to serve the time if the appeal is won. And secondly, it's to ensure that they don't flee the jurisdiction. So it's our position that the Dooley case, again, is similar to Ms. Benifield's, and we'd ask, and in that case, they imposed a bond of $100,000 and various conditions, including travel conditions and GPS. We recognize that the bond in this case was $100,000 prior to trial. We recognize that the circumstances are different after trial, and the case law says that it makes some sense for the bond to be a little bit higher following a conviction, because the concerns are different. So we'd ask the court to impose a bond of $150,000 with the same conditions that were imposed pre-trial. To remind the court, Ms. Benifield has previously surrendered her passport. She's perfectly willing and able to submit to GPS monitoring and to have a curfew as she did before. And finally, I'll note that there was at least 2 occasions where the state agreed to Ms. Benifield to travel, once to Orlando and once out of state, where she traveled through various states and went to Maryland and Washington, D.C. And those 2 orders have been entered into evidence. So even the state prior to trial was not concerned about Ms. Benifield fleeing the jurisdiction. And at that point, she was facing a charge of second-degree murder with a firearm, where she could get up to life in prison. So any incentive she had to flee existed then as well, and she remained dedicated to proving her innocence and proving her claim of self-defense, and she remains in that same position today. So we'd ask the court to grant the bond pursuant to those terms.
Thank you, sir. State.
Judge, first I'd like to address the Dooley case that defense brought up, and also to state for the record that I have read all the case law that the defense provided, and I've read through this Dooley paperwork that was provided. I disagree that it's exactly like this case. The Dooley case couldn't be further from the truth. Mr. Dooley was like 72 years old. He shot a stranger in his own home. He was given a supersedious bond and turned himself in when he lost his appeal. And then when it went back, where it was going to all start over, they gave him a bond again. So he had already demonstrated after the sentence that he could come back and turn himself in after the appeal. He lost the appeal. So I don't think Dooley is at all analogous to this case. Also, I don't think any of the cases that defense cited, while some of the factors may be similar, I don't think that they are analogous, because these things are so fact specific. And most of the cases that the defense cited, the court did not rule with enough specificity or with enough facts. And the appellate courts found their orders to be lacking. So the vast majority of the reasons that these cases were overturned was because the proper factual findings were not made. by the court. And that's individual to each case. So the case law says that it is a denial by the court must be based on record evidence, which the court's been here from the beginning, been to all the hearings, been to the stand your ground, been through the trial. You've gotten a plethora of record evidence that you can draw from. And also the court can consider any reasonable inferences from that evidence or that record evidence. The question is, what are the factors that distinguish this defendant from other defendants that maybe are charged and convicted with manslaughter or manslaughter with a firearm? What is the difference? And that's what I want to concentrate on, because that is the factor of the severity of the sentence and the specific factors of this case. I would agree, the state is not making an argument about the frivolous appeal issue. The state is not making an argument that she does not have ties to the community. There are issues with the fact that while she was out before, she never had consistent work, and she always relied on other people to fund her, and she is still relying on other people to fund her. However, but the state's main argument is going to be about the length of the sentence and the specific factors of this case that should tell the court that she is likely not going to show up after she loses an appeal. This case is manslaughter with a firearm. It was not a knee-jerk decision. It was not kids playing in the back of a car with a firearm that accidentally goes off. It was not a homeowner that shoots the pool guy because he thinks he's an intruder. It was not a DUI manslaughter where someone is drunk and accidentally hits someone. This case is very, very different from all of those other manslaughter with a firearm cases. This case is unique. This was the culmination of a 3-year campaign that started when she got pregnant. And the campaign started then, and she kept with that campaign all the way through the day that she killed Doug Benifield. And she not only stuck with that campaign, but she adjusted and she changed and she adapted to the things that were thrown her way. She started, for instance, with an injunction in South Carolina. When that didn't work, she tried to get an injunction here in Florida. When that didn't work with allegations of violence against her, then she started saying there was violence against the child. And when that didn't work, then it was sexual abuse against the child. She adapted her behavior every time the system told her no. This is a very calculated set of behaviors by the defendant. When all other options failed, she shot Doug Benifield to achieve her goal. And we all know the goal was to have sole custody of her child. And I've heard a lot of people today say that Ashley's honest and truthful, but I've also heard, and I think the court's also seen, that there are different sides to the defendant. And I think the court can consider the fact that a different judge, Judge Moreland, in her order before, specifically found that she was not credible. She was dishonest with the court and was not telling the truth. So if the court is to believe these friends of the defendant, the court can also take into consideration that another judge found her to be completely dishonest and not credible. This trial was her last attempt to keep her child. She'd already achieved the goal. She'd gotten rid of Doug. So this trial was her last step. And to be honest with you, I don't think she had an inkling that this court was not going to, or that this jury was not going to believe her.
Sorry, I had to get a fan on me.
She thought she was not going to be able to convince this jury, but she didn't. And after the trial, they told her they did not believe her. Her version of events was not credible. And this absolutely was not self-defense. So when you talk about how she complied with pretrial services and all that before trial, you have to look at it through that lens. She thought she was going to convince this jury So she complied. She did everything she was supposed to do. She showed up to every court hearing
Good
she was
point.
supposed to come up to. She kept her ankle monitor on. She did all of that because her end goal was to put her case in front of a jury and win, and everything would be fine. Now Doug's out of the way, and now she has her child. That's the difference in this case, because now her last ditch effort has failed. And the jury has told her no. And she has now been sentenced to 20 years. Her incentive to comply with pretrial services, with bond, has been removed, completely removed. So the court cannot consider the severity of the sentence alone. I would agree that the case law says you cannot say, well, it's a 20-year sentence, so therefore she might flee. But you are absolutely allowed to consider that sentence in conjunction with the facts of this case. So let's look at the facts of the case. 20-year sentence, the earliest she could be released, roughly, my calculations are correct, with good behavior is after 17 years. So that would be in the year 2041. Her daughter is 6. Her daughter would be an adult by the time she got out. Her daughter would be 23 years old. And her entire goal throughout this entire case for years and years and years, and still today, is to be with her daughter.
Shouldn't have unalived
And she
somebody.
knows that if she loses this appeal,
I don't
she
have
has
the
to turn
patience.
herself in. She was willing to kill a human being to meet this goal. There is nothing to prevent her, if an appeal comes back not in her favor, from deciding she's not going to present herself. It's actually based on her prior behavior and the prior motivation and the prior calculation. It's actually pretty likely that she would then absent herself from the jurisdiction and from the court to not
Or
face
unalive
the
herself and her child.
And that is what is different about this case and specific to this case, and the reason that this defendant should not get a bond. Thank you.
Thank you.
Not to mention
Yes, sir, rebuttal.
unalive herself and her child.
Before you start.
That's a risk.
Earlier, you had talked about the Dooley case in Hillsborough.
Yes.
I thought you had talked about another case from the second DCA, but I now see in your packet there's a Cooley. So I think I misunderstood. At one point you were talking about Dooley, and another one you were talking about Cooley.
Cooley is a case from the second DCA where the defendant was convicted of second-degree murder with a firearm and was denied an appeal bond by the trial judge. The second DCA reversed that, and despite the state's argument to the contrary, it wasn't simply because the order wasn't sufficient. It was because the judge improperly considered as it on its own the length of the sentence as a basis to deny the bond. That's why we rely on Cooley, because it's not appropriate under the Youngins test to use that factor alone to deny bond.
I understand. I just want to clarify the
Yes.
record that there's been references to a Dooley, which is 2 trial court orders, and Cooley, which is a second DCA case. All right.
And as far as the state's effort to distinguish Dooley, I want the court to be clear, there was 2 bond orders granting appeal. So although the state's correct that the second time they've already shown that Mr. Dooley could be out on appeal, and it's a unique case because he lost his direct appeal, then I was retained and filed, and he was out on appeal bond while that appeal was pending. I didn't represent him on that appeal. Then I filed an ineffective assistance of appellate counsel under Rule 9141, and they granted us a new appeal. At that time, a second appeal bond was granted. But at the time of the first appeal bond that was granted by Judge Ashley Moody at the time, Mr. Dooley stood in the exact same position that Ms. Benifield stands in here today. It was after a trial where he claimed self-defense, and he was found guilty of manslaughter and was sentenced, and immediately after the sentencing, the judge granted an appeal bond. So the procedural posture is identical, other than the fact that 2 different judges thought it was appropriate to grant Mr. Dooley an appeal bond. The state spends a long, and I want to note that Ms. Benifield voluntarily surrendered herself the same day the warrant was issued in this case. I'm sure that's reflected in the court file. Um, So there's no difference in her behavior compared to Mr. Dooley's behavior. The state makes a lot of argument about the specific facts of this case. And if you look at the Torpeles case, 2024, third DCA, they talk about the nature of the crime and the circumstances of the instant offense and say that you really shouldn't consider the nature of the crime because if the nature says, quote,
Thank
"If
you,
the nature of the
June.
crime alone were sufficient to deny bond, it would render the fact finding and application of the Youngin factors irrelevant." The state spends a long time talking about this detailed plan, and if you believe the state, this sounds like a first degree murder case.
Thank you, Dr. Bullbutter.
You know what? The jury didn't find a first degree murder. They weren't all, they weren't, Ms. Benifield wasn't charged with first degree murder. She was charged with second degree murder. The jury rejected that. They did not find depraved mind or malice. They found manslaughter. So, the state has a theory and speculates that this was a long plan and this was somehow premeditated. We're not allowed to second guess the jury's verdict. We accept the jury's verdict, and the court needs to rule based on the jury's verdict. It's not the state's opinion that there was a long plan. The jury's verdict is a manslaughter on that date. They have made no findings of fact concerning planning, premeditation, depraved mind. In fact, they rejected depraved mind and malice. This idea that she's been financed by other people, I didn't hear any evidence of that. I'm not aware of any evidence in the record of that. The state cites to, quote, record evidence. I'm not aware of a single piece of record evidence that supports the idea that she's going to flee, other than some speculation by the state that her last-ditch effort was to convince the jury, and she thought she was going to win at trial. I have a difficult time with that. I think most defendants that go to trial expect to win. That's why they're going to trial. So that's not unique to Ms. Benifield. It's not unique that she claims she's innocent. Thousands of trials happen in this courthouse where people go to trial and claim they're innocent. Some were acquitted, some were found guilty as charged, some were found guilty of lesser included offenses. The idea that she went to trial and thought, quote, she could convince the jury she acted in self-defense, number one, that's her right. Number two, again, it's not unique to Ms. Benifield. So I don't agree with the state that that's a legitimate basis to deny bond pending appeal. She has an extraordinary level of support in this community. She has strong issues for appeal. She has a long history of complying with the conditions of release. There's just simply no evidence in the record that she's going to flee except some speculation from the state. So I'd ask the court to grant the bond.
All right. Thank you all very much. I'll take it under advisement and issue a written order.
Thank you, Judge.
Thank you.
Written order.
All right.
This ought to be fun. Excuse me. Allergies, man. I want to see what happens in the courtroom. Look at the it's just so bad. He is keeping an eye. Oh, look at, is that a sheriff? Yeah, that's a sheriff officer or deputy or something. She's with the sheriff's office, but look, oh, they're on opposite sides of the fence, but they are at least being kind and cordial. I kind of like that spicy old lady. Can I be her? Can I be that brave and spicy? She said, I promise, but I don't know what she's talking about. She's hard to lip read because everything is real stiff. Oh, there's that Jesus dude with the hair bun. Oh, he was so cute. Um, I think was she granted a new trial? I don't remember. Can't remember. I do not remember. Okay, that'd be it on that live. Here is Kohlberger, I believe. Okay, we are going to look at the Idaho versus Kohlberger. There was a motion hearing today. We're going to watch that. And then we're going to jump over to another live with a bunch of other stuff. But that trial, I can't get it. I know he's on trial today, but there's no camera in court. Thank you so much, Bama Green Eyes. Appreciate you.
United States Supreme Court looked at but did not decide the issue of press access to suppression hearings, that the requirement of a public trial is for the benefit of the accused, that the public may see he is fairly dealt with and not unjustly condemned, and that the presence of interested spectators may keep his triers keenly alive to a sense of their responsibility and the importance of their functions. And in turn quoted other cases. In addition to ensuring that the judge and the prosecutor carry out their duties responsibly, a public trial and public proceedings encourage witnesses to come forward and discourages perjury. Your Honor, prior to closing a criminal proceeding, a court must afford those excluded from the proceeding a reasonable opportunity to state their objections. We appreciate the court providing us that opportunity here. And the court must also comply with the requirements set out in Press Enterprise 2 before it can close those proceedings. A criminal proceeding can only be closed if the court makes specific findings on the record as required by that case. And those specific findings need to be sufficient in writings, insufficient so that a party excluded can challenge them. The Ninth Circuit has explained that a court cannot be closed in criminal proceedings unless such closure serves a public interest. There is a substantial probability that in the absence of closure, this compelling interest would be harmed, and that there are no alternatives to closure that would adequately protect the compelling interest. And that's in Oregonian at 920 F. 2nd at 1466, quoting from the Press Enterprise 2 test. Here, Your Honor, the interest parties are not arguing for a blanket order opening the court. We are arguing for the court to adhere to this long-established process of determining how and under what circumstances a court could be closed for a hearing. For many of the media outlets we represent, even in national security, child sex assault, and organized crime cases that they cover, the process that we are seeking has been carefully followed. The public and the media have a right to appeal unwarranted closures of a courtroom, but they're unable to determine whether the court is being closed appropriately because the court so far has not made public the most basic information regarding the reasons for its closure. The defendant in this case, in both its January 13th and January 21st filings, seeks an open hearing and asserts that an open hearing is of utmost importance to him. Therefore, any concerns about the closure being required to ensure the defendant's right to a fair trial are moot. And as Mr. Kohlberger pointed out in his motion to hold an open hearing, the Supreme Court in Waller held that when the defendant objects to the closure of a suppression hearing, the hearing must be open unless the party seeking to close the hearing advances an overriding interest that is likely to be prejudiced. The burden is on the party seeking closure. That's from Oregonian 920 F. 2nd at 1467 and Brooklier 685 F. 2nd at 1167. As we understand it, Your Honor, the interest being advanced by the state is concern for information being provided to the potential jury pool and possible inadmissible evidence being discussed in open court. But that is inherent, Your Honor, in any motion to suppress hearing. The whole basis of the hearing is to see whether the evidence should be excluded or admitted at trial. Concern about the public maybe learning about this evidence, and even if it ends up being inadmissible, is therefore not an overriding interest. And absent that some evidence that this discussion that would occur in the hearing would prejudice, would taint a jury pool or provide information that would be difficult to seat a jury, I think that is also not sufficient evidence for this court to find that it's a compelling interest and warrant closure of the hearing over both Mr. Koberger's objection and then the right of public access. It also appears from Mr. Koberger's filing yesterday that the state asserted that Mr. Koberger's acquiescence to the non-dissemination order is somehow a basis for them to argue that Mr. Koberger cannot now object to this closure. Not certain if that was the argument the defense, that the state advanced, because we haven't seen their pleading. It's not on the cases of interest website. But as I understand the non-dissemination order, Your Honor, and its purpose, it's directed at comments or statements that are made outside of court proceedings and pleadings, and not at what can be said by the parties or their counsel in the courtroom. And the very purpose of the non-dissemination order, as I understand it, Your Honor, was to prohibit those sorts of extrajudicial comments by people who would be in the know, but that in-court proceedings are precisely the kind of information that should be available to the public as the case moves forward. Your Honor, I would submit also that there is tremendous public interest, and it serves a tremendous public good for the public to know at the time that it's being considered the evidence, whether the evidence that the state seeks to introduce at trial was gathered in a method that is constitutional or meets evidentiary thresholds for admission. A motion to suppress may be the critical stage of a criminal case. If essential evidence is suppressed, then the government will not be able to meet its burden of proof at trial. Indeed, Mr. Koberger made that exact argument in his filing yesterday. The purpose of the IGG was to investigate a criminal case. What is more, without IGG, this case would never have been brought against Mr. Koberger. The public should know precisely what law enforcement and prosecutors did in gathering such evidence and why and how the defendant thinks that was illegal. The court in Waller, when it was talking about the aims and interests of a
That judge looks so bored.
public trial, noted that those aims and interests are no less pressing in a hearing to suppress evidence. And then they pointed again to several of the individual opinions in Gannett, the case where many Supreme Court justices opined that if they were addressing the question, they would say there's a First Amendment right of access to suppression hearings, but they didn't reach that question. In Gannett, the comments that many of those justices made was that in many cases, the suppression hearing was the only trial because the defendants thereafter pleaded guilty or the evidence was suppressed and no case went forward. And similar reasoning supported press access to preliminary hearings in one of the few Idaho cases to address access to pretrial hearings, and that was the Cowles case. In Cowles, the Idaho Supreme Court noted that the process in conducting preliminary hearings in Idaho is likewise sufficiently like a trial to generally justify public access. And they pointed to the Supreme Court opinion in Press Enterprise 2, where they state that because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. The preliminary hearing in many cases provides the sole occasion for the public observation of the criminal justice system. And that may be the case in a motion to suppress hearing, particularly if either that motion is granted and not sufficient evidence exists to go forward, or even it is denied and a plea deal follows the resolution of the motion to suppress. In a Franks hearing, Your Honor, the court is addressing the very critical issue of whether a law enforcement officer made deliberate or reckless false statements in an affidavit submitted to the court. And prior to holding such a hearing, a court is to determine that whether the defendant has made a sufficient threshold showing that an actual hearing is necessary. An actual Franks hearing, in my experience, Your Honor, is unusual. On issues as critical as these, whether evidence was gathered properly and whether law enforcement made deliberate or reckless false statements to a court in gathering evidence, there is significant public interest, and public access plays a significant positive role in the functioning of the particular process as the court outlined in the earlier cases I've identified. It's particularly true here, I think, Your Honor, with the Franks hearing, where there is that question regarding the truthfulness of the officer involved.
Hello,
In
Angela.
any criminal case, I would submit that it's of extreme public interest to know whether a law enforcement officer swearing that
I'm
they have
sorry
told
you're
the
bored.
truth in a filing with a judge that will be used to gather evidence that can significantly impact the life, liberty of an accused, whether that law enforcement officer did in fact tell the truth or whether the officer made deliberate or reckless false statements. I think it would be different, Your Honor, if it were a private citizen who made a misstatement of facts and there was a hearing about perhaps that person. The calculus might be a little bit different, but this is a person, a law enforcement officer who is cloaked with authority and has the ability to seek process, to get evidence, and ultimately lead to charges against an individual. Your Honor, the last thing that the court has to look at with respect to whether or not to close a hearing is whether there are alternatives to closure. And Your Honor, it is a little difficult in this situation for the interested parties to specify what that alternative to closure might be. But sort of looking at the documents that have been filed in this case and understanding that one of the initial concerns with the IGG evidence is the identity of perhaps family members of Mr. Koberger, I would submit that there are two alternatives at least that might address that. One is that it's possible, of course, to show exhibits on a monitor in a hearing in court in a way that they're not displayed to people who might be watching online or in the courtroom, similar to what is done when there is a piece of evidence or an exhibit that is offered, but it's not yet admitted. Would also submit, Your Honor, that perhaps redactions or some sort of general identifier, person one or person two, in the place of a particular name would be sufficient if indeed the concern is revealing the names of relatives of Mr. Koberger. That's very similar to a process that is done in healthcare fraud cases when we're dealing with individual patients whose records may be at issue in a case, and not a medical malpractice case, but a healthcare fraud case where we're looking at the billings, and those individuals are often identified, for example, by a random number or by a Medicaid identifier number, and not by their name. So their names are never revealed in the course of the proceedings. And so, Your Honor, we would submit that alternatives to closure such as that would be available to the court if the concern is identifying those particular names of people who are extended relatives of Mr. Koberger. Finally, Your Honor, openness and transparency are more important than ever in maintaining and restoring public confidence in our government institutions, in our courts, in law enforcement, in prosecutors' offices, and in institutions of the media. Open hearings, like an open suppression hearing, are necessary to let the public see how this critical part of our criminal justice process works. Thank you, Your Honor.
Thank you. Does either the state or the defense wish to add anything based on Ms. Olson's argument that was not previously presented?
I would like to make a record on behalf of the defense.
Beyond what you did yesterday?
It would be consistent with what I did yesterday.
Okay, but I heard what you did yesterday. So do you have anything new to add?
I don't have new information to add, Judge, other than having the ability to talk with the team about what your suggestion was and our concerns about arguing in open court. Would you like me to just address that?
I'm not sure what you're referring to, so I apologize.
So we had discussed that the evidentiary hearing portion of it for the IGG would be closed.
Correct.
But that we would argue the legal arguments in open court if we did not talk about the evidence that was brought out in the closed hearing And after thinking about it overnight and talking about it today, we do not think that we can parse the argument that way. So it's still our position that all of this should be held publicly, openly in court. And that's our same position with the Franks. The Franks proffer, with the exception that there will be, in the proffer, there will be a need to talk about specific names and in particular names of some lay witnesses in directing the court to the 1,000 pages that were submitted submitted under seal in relation to the proffer.
Would you guys prefer, thanks to my fabulous friend Toxic over at As the Gavel Drops, you guys, she's amazing. And her crew is amazing. As the Gavel Drops has just handed me 2 documents pertaining to this case. And if you are a document junkie, go to your Discord, go over to As the Gavel Drops, create an account, verify your account, and you will be able to have access to all the documents that we do. Also, don't forget, they just started a YouTube channel with shorts. So go over there and make sure you like them. I think we're going to read this. Is that okay with y'all? I'm going to stop share screen. I'm going to share screen. We're going to. I'm reading this for the first time with you. Give me a second. I'm trying to get everything lined up. I love having all these extra streams, windows. I gotta line everything up. Takes a hot minute. And let me embiggen this to fit. Hopefully it will show up on your end. It did not. Why is it not? Embiggen. Maybe I got the wrong one up. Maybe this is the one. All right, there we go. Here we go. Order giving the proceedings for January 23rd on the 24th hearing. Kohlberger. The hearing set on January 23rd as a matter will proceed. The follows at 9 a.m. January 23rd. It is ordered. So that's that. And then bring this over. Why can't I embiggen it? Oh, Sensei won out. Oh my gosh. I gotta go see that. Share. Get on screen. And embiggen just a little more. Oops, wrong one. Not what I wanted. Cancel. There we go. I need to get this where it does a preset for me. It doesn't, and it frustrates the hell out of me. Okay, the following motion is heard as an interest in the parties to memorandum of the support of the motion to be heard in the interest of parties. And number 3, proposed order granting motion to be heard as interesting parties was received by the court immediately prior to scheduled hearing with the parties at 10 a.m. Thursday 21. The document shall be docketed as an exhibit to this order. Given the untimely filing, the court was unable to accommodate the request for a hearing by the petition mentioned media interest. Today's hearing with the parties was designed to establish a schedule for the hearing on January 23rd and 24th upcoming hearings and was closed to the public because the very purpose of the hearing was to discuss the specific information currently sealed must be protected during the upcoming hearing on January 23rd and 24th. So, and how best to do so. To formulate the plan to allow as much public access as possible to the upcoming hearing, the court needed to have today's hearing closed to have a candid discussion with the parties about the information. Order denying petitioners' motions to be heard prior to January 21, 25 hearing, page 1. So it was denied. January 15th, the court issued a notice of hearing ordered regarding January 2021. Hold on. Matt, can you come get Sensei? And my son goes, oh my God. In that order, the court set closed sealed hearing on number 1 hearing defense motion, unsealed matters related to the request to suppress evidence seemed from the use of the IgG DNA, considered what portions, if any, under what circumstances should the various motions be heard. So down here, we're talking about the American Broadcasting Company's ABC, all of these different entities that want to stream this live respectfully. Oh gosh, there's a lot of people. Both state and federal courts often permit the media to intervene in criminal cases, limited basis, or at least file a motion of interest parties, the defense of public access for free speech, including in Idaho. In the alternative, the interested parties request an opportunity motion to be heard. Oh my gosh, a lot of parties wanted to be heard. This is the introduction. In other words, this is a motion to allow this hearing to be broadcasted. January 15th, ordered the court's closed sealed hearing for that one. Wow, y'all. I'm skimming because we got to get to something else. Moreover, as at least it pertains to the upcoming discussion on the court's subsequent hearings, it is unclear how this discussion would prejudge the defense right to a fair trial or measures, if any, have been considered in the order to protect the defendant's rights and the public in the matter that is less extreme than locking out the public altogether. As the interest parties understand the issues, it appears unlikely that any potential confidential information would need to be discussed during the hearing to have a full and frank discussion on the openness of any upcoming hearings. Additionally, as the court is well aware, this case has undeniable significance in the state of Ohio and its citizens. As the Supreme Court explained, controversy opens and enhances both the basic fairness of the criminal trial and the appearance of fairness of the essentials to the public. Conclusion. For the reasons set forth above, the interest parties respectfully request the court to grant a motion, allow an opportunity to be heard. So they're fighting, the news media and a lot of the news people are fighting to have access to this trial. And the order was granted for all parties in interest to be heard, which is what we were seeing just a minute ago. Let me pop that back up there. Oh, we're on this side. I forget where I put my stuff. Okay, let's continue.
All right. Well, with
So
respect
that's
to
the
with respect to the
information
names,
that I have.
I'm sorry. With respect to the concern with respect to using names, submit a list of names with initials tomorrow, and you can use the initials.
Okay, we can do that.
Anything from the state, Mr. Thompson?
Not for me, Your Honor. Mr. Nye was actually speaking on behalf of the state yesterday. I'll defer to him.
Mr. Nye?
No, Your Honor, nothing beyond what was said yesterday. Thank you.
Well, I appreciate the presentation today. I will note this case is a
Hello,
little bit
Dave.
of an unusual
Hello,
posture in
Swan.
that there was previously a non-dissemination order issued in this case in which it was clear the tract of the court and at the time the parties was to avoid given the media scrutiny, the potential for impacting the jury pool that exists here with evidence that may ultimately not exist and evidence that may not ultimately be admissible. That order was challenged, I believe, by the press at the time, and the full hearing was held on that, and the judge issued an order on that.
Hi, Eddie.
The closure of the proceedings thus far have been consistent with that prior ruling by the court, for which the petitioning parties were given an opportunity to be heard previously. I don't think much has changed in terms of the need to protect the jury pool here, given the intense media scrutiny that has and continues to follow with this case. Part of the rationale presented to the court yesterday for opening it was in order for the defense to make their case to the public. It's exactly why it's not open. We will be challenged under the best of circumstances of obtaining a jury that is not been overly exposed to this, and in particular exposed to evidence that ultimately may not come into this trial. I am, as I told the parties yesterday, particularly sensitive about closing things when we don't need to. And I think that there has been to date a over caution in asking that I seal things by stipulation that perhaps don't need to be sealed. And I've asked the parties to stop that, frankly, and to provide better rationales as to why I should seal what they're asking me to seal. That said, with respect to in particular, the IGG issues, particularly where I don't exactly know what the evidence will be forthcoming, I am concerned about the potential impact on a jury pool. In this case was moved to this court because of the defense's assertion that they could not get a jury pool in northern Idaho that would be unaffected by the case, even with the non-dissemination order in place. The media here in Ada County is as, if not more, intense. And so I think there is need to be careful when we are addressing
Thank you, Kelly.
evidence that potentially is not going to be evidence in the case because of suppression motions in limine and the like, which is the concern that I have in particular with the Frank's hearing, as that does appear to be evidence that may not come in, and it may not be evidence that has been particularly disseminated to date. As I talked with the party, there are other issues that I've asked the parties not to address specifically as it relates to some of the motions to suppress that doesn't need to be discussed specifically. For example, the evidence produced by the warrants they seek to strike. And for that reason, my intent has been and continues to be that we will have as much of this hearing open by way of streaming possible. I have not and will not open the courtroom itself to parties in the courtroom because of the need to close it if I find or the parties suggest to me, and I agree there's a need to discuss something at that moment outside the public's reach, which is easy to do by simply going offline for a minute. And that's what I intend to do tomorrow. In particular, the evidence with respect to the IGG, I think at this point it's appropriate to, and I will issue an order shortly to keep that out of the public domain for the time being. Now, that may change down the line. My order certainly on the issue will ultimately give some information so that people can follow what happened from a legal perspective. But some of the factual details, until I know what those are, and I've seen that, I can't make that determination better. And so I think that this is the best way to proceed because I can't unring a bell once it is wrong with respect to potential evidence that in particular may not be evidence in this case. And so my intent would be to proceed with the evidence portion of the Franks hearing as it relates to IGG in a closed environment. I think we can decide at that time before we go online whether we can have the IGG portion of the Franks proffer publicly. The intent is, I think we understood from discussion yesterday that the rest of the evidence and the arguments, both on Franks and suppression as it relates to everything else, we should be able to do public. If there's an issue that is specific, like Ms. Massoth brought up, about the need to mention a name that we need to protect from unwarranted harassment, which has been a concern in this case, we can certainly refer to them by initial, particularly if you give me a roster with initials or other identifiers you'll be using, then I can follow along. And I think that's the better way to proceed so that we can do as much of this in open light as possible. So I appreciate the petition. I don't think it has changed. I appreciate the defense has shifted its position to a degree here. I'm concerned that the purpose of the shift is to try the case publicly as was offered to me. That doesn't give me comfort, to be frank. But for the meantime, until we can, I can get a handle on the exact evidence that does in fact come in, given that it is potentially evidence that will not be admissible and anyone who hears about it may therefore be removed from the jury panel. I think it's better that we proceed in this fashion for now.
May I raise one other issue, Your Honor?
Briefly.
Thank you, Your Honor. So first, Your Honor, with respect to the non-dissemination order, respectfully, we represented the interested parties at that time as well. In our understanding of those proceedings, it was amended a couple of times. The second time after we moved to intervene and challenge the dissemination order then in place. And as I understood Judge's the proceedings in front of him and the non-dissemination order, the purpose of that was to preclude extrajudicial statements and was not to preclude the attorneys from saying things in court that would be made public. The goal was to make sure that there was accurate information from people knowledgeable about the proceedings, and that was the forum in which they could do it. And I would also note that Rule 3.6 does have sort of this rebuttal portion to it that allows if the defense, if there is a statement that is made, under Rule 3.6, the defense is permitted to make public statements to sort of counter that. And I think that's probably what the defense was getting at in its submission to the court. And then finally, Your Honor, are the court's statements in court today intended to be its specific findings regarding the the manner in which the court is to implement the Press Enterprise 2 test, or will there be a written order so that my clients can be adequately prepared to decide what next steps to take?
Yeah, as I indicated, I intend to issue a written order following today's hearing. I don't think that what you said accurately reflects my understanding of the defense's position yesterday, but I appreciate that. I do understand Judge's prior order to be dealing with extrajudicial statements because that's who he could control at the time, were witnesses and parties. But I also understand from a review of the record, there has been a concern throughout this case of exposure to evidence that may ultimately be inadmissible, and that prior proceedings were closed for that purpose, consistent with Judge's ruling at that time. I agree it would be an extension of that, but in general, I think that's where they've been throughout this case. And at the end of the day, regardless of the outcome, the likelihood is everything will be unsealed. And before then, as soon as it can be done in a way that protects the case and the jury pool, which is the parties' rights, both parties' rights to a fair trial is paramount, as is the public's right to know. But I also have to weigh that against the ability to have a fair trial by getting a jury panel that has not been tainted by the publication of widespread publication of evidence that may not be admissible at trial. So it's a bit of a narrow path for the court to have to tread, and I appreciate that, and I appreciate that that calculus isn't always in the direction that one would hope, but I am doing my best to make that calculus in a way to ensure the rights of the parties and to ensure a fair trial, and that we can do that as quickly as possible. All right, so I will issue an order forthwith, and tomorrow we will come forward with public hearings just as soon as we can. Further, if after hearing that evidence, I determine it doesn't need to be protected, I will order a transcript be prepared, and I will order that be produced. But in the meantime, I think I need to take this course, so I appreciate that. Thank you.
Thank you, Your Honor.
Okay, guys. Breaking news. Breaking news. I got something y'all gonna like to hear. This is Karen Reed. I'll have to go live and do a more detailed once we get the document. All document people, toxic, Discord. Keep your eye out for this. Let me get it on screen. Let me try and get this at the stage. Okay, according to the new defense filings, this is on X. All original DVR footage. Oh, excuse me. This is from Ted Daniels, Karen Reed filing. Karen Reed legal team is seeking $12,229.57 reimbursement for fees and travel expenses paid to the defendant's expert hire to examine the security camera system at the Canton Police Station. According to the new defense filings, all original DR footage from the related case has been destroyed. All have been destroyed. Huh? What? Are you shiting me? At best, due to improper preservation by the Commonwealth, and the expert trips were futile. The defense argues original footage is required to verify the authenticity of the condition of the right rear tail light of the Lexus SUV at the time it was entered law enforcement's custody. It is perhaps one of the most crucial and highly contested issues of the case, and they don't have any footage. It was destroyed. The filing also mentioned the inverted video shown on Reed's trial and new surveillance video the prosecution provided after the trial in October that shows prosecution witness Brian Higgins arrived at CPD at 1:26 a.m. and minutes later speaking on the phone at 1:34 as he left the PD, according to defense. I reached out to Special Prosecutor Hank Brennan and will update as he responds. Here is the photo. Oh my God. Y'all, could this be a mistrial? Whoo. Oh my God. Y'all, this is insane. Then they should not be able. I'm watching. You guys all are court people. Thank you. I did toxic. All you court people, you need all of our documents. Please stay on top of this. This is insane. But I want to show you something else that I have, and it's pertaining to this case. Let me get it up. I have a lot up and running for, I want to talk about something that's close to home. Let me delete that. I got to get all of the files. I've got like 20 different things running. Kid you not. Oh, where did it go? I got to pull something else up concerning this. There's a video I just saw. Okay. I got to find it. Where is the said video? I'm sorry, I'm looking. Okay, we're going to get rid of that. Sorry, guys, be patient. This is a lot. I've got like 30 windows open here. I kid you not. I literally do. Is it under that? No. There's a video that was just produced by Turtle Boy that I wanted to show y'all. No, that's not going to be over there. I just saw it. Y'all, what do y'all think about that information? I'm wondering if this can cause a mistrial. Already. I wonder if this is going to cause a problem. I see the I want to see the full video. It's not letting me pull it up now. Why not? Why not? I'm not good. I did hide it. Okay, that's what I need. I hate all these ads that pop up. You can't find anything without these ads. And they hide everything. That's not what I'm looking for. Why can't I play it? Y'all, I'm frustrated. Here it is. Found it. We're going to have turn sound off. We're going to embiggen it. We're going to unembiggen it and put it over here. And then, oh, what is it with all these ads, y'all? Getting ridiculous. It's getting to the point you can't even see the content for the ads. Oh, yeah. Okay, I got it. Let me get it up. I want y'all to see this. One of the things that I've been kind of thinking about, and I'm glad we're getting to see this again, is because we are now in the winter season when we had the situation with John O'Keefe. Don't know what the heck that was. When John O'Keefe was unalived. So now we have the actual footage of somebody driving by the house. Go Turtle Boy. You and I don't always agree, but I'm appreciating you right now. Look at this. He's driving. Look right there. You tell me you would not be able to see let's play it again. You would not be able to see somebody laying in the snow. Look. Drove by. All those people drove by and could not see. I want to see this picture. See right there? TB, I did shout you out. You are listed. Please don't copyright me. You did good work. Can't cover up footage of the car driving by 34 Fairview Road during a snowstorm at night shows there is no way John O'Keefe's body could have been lying in the lawn before 3 a.m. and not be seen. Look, you tell me. Yep, that too. Look at that. Let's watch that beautiful bean footage again. Let me embiggen this so I know what the heck I'm doing. Come back. Look at that. There's no way. There's no way you could not have seen him sitting there. No freaking way. Here's a video. How could you not see a person? Just in my humble opinion. I'm with you, Turtle Boy. I am with you 100% with you on this. You are so amazing. I don't agree with your language and I don't agree with how you say things, but what you're saying is true. You would definitely have seen somebody or something laying in that yard. There's no way you wouldn't. Okay, guys, we are going to hop onto another live. I hope this works. Let me get all my feeds up. Let me get all my feeds up because I got to switch. We are going to hop on over to another live. There was something that happened in my hometown. Well, next to my hometown. I lived in San Antonio for a long time, so I still call it a hometown. I don't live in San Antonio anymore, but we're going to hop on over to another live. I hope you join me. I'm going to get started over here and then I'll end this live because there's a lot happening today and I'm going to separate these two lives. Thank you for your understanding. And there we go. Play intro. So once again, thank you guys very much for hanging with me. Hop on over to the other live. Have a great day. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.